Let's call the case. Peel versus Gerler. Ms. Gerler, are you there?
I am unmuted, Your Honor. This is Ms. Gerler, and my last three digits are 343.
Yes, ma'am. Are we on this case? This is set for non-jury trial. This was a termination action. Ms. Gerler, what's your defense to the termination? There's a month-to-month lease, correct?
Well, there was a change in agreement as well, Your Honor, and history and backstory that is very much applicable to this situation. I would like to first bring to your attention that I'm a lifelong, long-term renter. Residentially, longest term 13 years, and 8 years. Commercially, I leased an upstairs office at Nichols Arcade from Wilson White Management at that time for 15 years. I have never had a problem paying my bills or until COVID, and which I contracted in fall of 2019, which began a horrendous downhill slide of health, illness, income, and has basically rendered me indigent at age 68. I have tried to get help from agencies, and I have not even heard back from Hawk as to, after my appointment on Monday, as to, how things went. There are many issues beyond what is apparent on the ledger sheet. And when I initially agreed to move into this home, I had another one lined up as indicated previously in our hearing. I requested to stay only 3 months. The plaintiff demanded 6 months because she needed me to watch her home while she and her husband, the landlord, went to Florida for a very long vacation, over 6 weeks, I believe it was, in 2020, beginning of 2022. Problems arose right at the...
Ma'am, can I just stop you one moment?
Absolutely.
All right. This is filed as a termination action. And fundamentally, the issue is going to be because of there is no lease, is going to be why shouldn't you move?
Your Honor, I've been before you previously, and I have 3 functional disabilities, electrohypersensitivity, which makes me incompatible with any of the wireless utility meters, internet, Wi-Fi, cell towers, etc. This home has also been mitigated for me with the acknowledgement and cooperation of the landlords who, years prior to my tenancy, had replaced the utility meters with opt-out meters when I made them aware of all the issues of electromagnetic frequencies. They have Ethernet installed, and we had things mitigated to reduce the interference of electricity and wireless devices, including Stetzer filters in the plugs of electrical plugs of the home, which was also by verbal agreement, my loan to them on their above floors for the use of the landline digital cable phone, and that which has been denied to me and does not allow me to send more information to the court. My impression from the papers that I was given, and as I indicated in the prior hearing, Judge Barr had said other ones needed to be entered that apparently were not needed. This is collection and termination. Had I had my phone line not turned off to me after I faxed in the confidential contact information requested by the court, I would have been able to send to you a letter from Ms. Peel that she wrote to the Department of Health and Human Services when I applied 3 years ago in 2020, stating that, you know, I was in dire financial circumstances and having problems paying rent with the prior landlord. I did not know at that time I had long COVID. It was also the plaintiff who did the research and informed me in late spring of 2022. But they have awareness of all my frailties and vulnerabilities, which they have not been honoring in any degree, and knowing how very difficult it is for me to find a safe place to live, and I'm going to have to move rurally. There is no housing, affordable senior housing, et cetera, I can be in because of everybody else's need for wireless devices, which are beyond hazardous to me. I suffer from post-traumatic stress disorder from a car accident where when I requested aspirin, they wouldn't give it to me, but narcotics and opiates that were not compatible with me, and a closed head injury that was not diagnosed for a year and a half. So I have 3 strikes against me just as a person functioning in the world with the long COVID, the electrohypersensitivity, and the PTSD. I have been subject to some very harsh, intrusive, invasive treatment as a tenant here for some time prior to these recent occurrences. And the assumption that one has of autonomy, privacy, and enjoyment of property when renting a property have also been denied me.
Okay, Ms. Gerler,
Yeah.
I'm going to stop you for a moment, okay?
Sure.
Those aren't a basis for me not to grant a judgment to the plaintiff, or at least possession. The issues that you're talking about may relate to their monetary claim. But as to the issue of possession, why shouldn't the landlord get their property back? Let me try to put it that way.
Your Honor, I was under the impression that Hawk and other agencies would be assisting me with the back rent so that I would have time to find a suitable place, because I will literally be on the street with my possessions. I would say that would be today's equivalent of delivering a head on a plate. I have nowhere to go. I have no vehicle. I live as a virtual shut-in with restrictions.
Okay, I understand that. Your name, ma'am?
Pamela Peel.
Okay. Ms. Peel, you've heard all those circumstances. You're aware with this defendant. How much time would you give her to vacate the premise?
Your Honor, I have asked her to pay up or move out since June of 2022. I am a very kind-hearted person. I was aware of the circumstance. However, this whole thing, I'm in my 70s. I depend on my rent for paying my bills. And I kept asking her, hoping, praying that she would leave. And she was unable to do so. And I can no longer carry her on my back.
All right.
Literally, it's.
I hear you, and I understand because of the pre-trials in this case, where this case was. So how much is owing?
The amount of rent owing is $11,995. That's about.
Okay, right. Right. So the problem for both of you is even if Ms. Gerler, and just listen to me, even if Hawk were to assist you, given what their maximum amounts that they would be able to assist, you'd still have to come up with $9,000. Okay. So there's part of that's the big issue. So when
Your
we
Honor,
get to that,
pardon?
pardon?
I would just need to inquire about those figures because when I spoke with Autumn on Monday, she said that they had, I believe, a maximum of $5,000 they can issue. She was going to reach out again to Faith in Action for me, whose monies Ms. Peel, the plaintiff, declined in July of 2022, and at that time, other affiliated agencies would have brought me current there was $2,985 owing, but because the plaintiff refused the offers of money, that other monies were not forthcoming. And the plaintiff also knows I have been sequentially ill on a regular basis. There's no soundproofing between the downstairs, upstairs. They hear me hack, cough, sneeze.
Ma'am?
So
ma'am,
I'm letting you
Ms.
know
Gerler,
it is illness, chronic illness. Yes.
Ms. Gerler, whether it's 5,000, 3,000, we can get into that argument, but you'd still have to come up with the other 7,000 if it's 5,000. I mean, the problem is that those other amounts are going to be your difficulty.
Your Honor, I don't believe that I should be culpable and responsible for the monies they declined in July 2022, the $2,985, which would knock the equivalent of $3,000 off of the total. When I spoke to Autumn, she said that she would also pursue with Faith in Action. I was denied by Department of Health and Human Services for reasons I don't know, because my mail is being held and I have not gotten that back to me. When you're only making $1,100 a month on Social Security, I don't know why I was denied, Your Honor. I can no longer work. I was self-employed.
I understand that, Ms. Gerler. Ms. Gerler, I understand all of that. But when we all boil it down, the reality is the funds aren't there. And so if the funds aren't there, what's really going to end up happening is you're going to have to move. As I see it, and I'm looking at the case, it isn't a matter of whether or not you will have to, it's a matter of when.
And I would ask that the landlords, knowing my circumstances and situation, please grant some lenience in this case, as they may be leaving at the end of the month to go on a 2-month Florida vacation. I have tried even to get people to help me pack, and people are not available due to our upcoming holiday. I am at this point.
Okay, Miss
I'm not
Gerler,
standing
let me
before
ask you
you.
this.
I'm weak.
Miss Gerler, in your mind, how much time do you need to move?
To be very
Not saying I'm going to
realistic,
give you
sir,
that much time. How much time? When could you be out?
to be realistic, sir, requiring the assistance and the fact that I may move very far away, I would likely need till the end of January because I have quite a bit of things to take with me.
Okay, so you need to the end of January.
Yes.
Ms. Peel, would you give her to the end of January to move?
Consult with my husband for 1 minute.
You look like the brain trust, but yeah, go ahead. You can talk.
Would be willing to do January 15th.
Okay,
And
so you won't do
Your Honor,
January
that's
3rd.
not possible. I
Hey,
apologize
Miss
for
Girl,
interrupting. It's not
Miss
possible,
Girl,
sir. Yeah.
Miss Gerler, hold on.
Yeah.
Anybody have anything else to say before I give you my ruling?
Your Honor, if there was anything else beyond hold on, I did not hear it. This is,
No, okay. I was just asking if anybody else wanted to say anything else before I issue my ruling.
Your Honor, I would like to say, if it is possible, they hold $995 in as a security deposit, with which they could keep for the month of January if I were allowed to stay. And of course, we'll continue to look for additional help, but to pay. But they know my circumstances, and
Yes, they do, Miss Gerler. So here's what I'm going to do. I don't think that there's really much distinction between the 15th and the 31st. And given your circumstances, Miss Gerler, I'm going to grant a judgment to the plaintiff for possession. The writ will not issue till January 31st, 2024. There
thank
is
you
an
so
issue
much.
regarding, you're welcome, but there is an issue regarding monies that would be owed. And so a trial on any additional monies that will be owed will be set for March 5th, 2024 at 9 a.m. in person. That will give time. The reason I'm setting it out to that date, that will give time by the time she vacates the premises to then you can do the inspection and you can have all of the damages that we can figure out and hopefully have it told. All right. Any questions from
Your
either?
Honor, the only comment that I have to say, and I'm very sorry, but I cannot appear in person. I can only appear via remote Zoom
All right.
due to my disability.
I understand that, ma'am. All right. Yes, ma'am.
Your Honor, you have struggled getting into for many months now. Since I asked her to leave, pay up or leave from the possession that I filed a few months ago, October. The tenant has not paid us any rent, and she will not let us have access to our mechanical room, which unfortunately is, we have to have access to the mechanical room through her apartment. And we give her notices, and then we have people come, and she will not, oftentimes won't answer the door, or will just say, you know, whatever excuse, and then we have to continually deal with it. That's why I really didn't want to extend the time, but I understand your perspective. It's been very difficult dealing with her. And
This is not great.
looking forward to this being completed. And I just want to, we do want access to our money.
All right. Under paragraph 10, when you fill out. Yes, Ms. Gerler.
I would like to respond to that, please.
Which part?
The part about them wanting access to their mechanical room, or access to the apartment. I have been subjected to an increasing amount of hostile, threatening, aggressive action, pounding
Okay,
on
Ms.
the door.
Ms. Gerler.
I would allow them in to do whatever they need to do, but not by myself, with someone else. I have not resisted them. I have been literally ill when they wanted to
Okay,
come
so
in.
here's, Ms. Gerler, here's what I'm gonna do. On the judgment form, when you fill that out at the counter, under paragraph 10, the defendant is to allow plaintiff access to the mechanical room upon 48 hours notice. Ms. Gerler, that will give you time to get somebody there. That's adequate notice that you, if you're gonna have somebody else go in and look, you got the time to do it.
Your Honor, that is totally fair, and I
Thank
am
you.
thankful.
That's what I do.
I'm very impressed with you, Your Honor, so thank you.
Well, thank you, Ms. Gerler. I appreciate that.
Will you put that in writing or do I need to?
You need to write that under paragraph 10 on the judgment form when you pick one up the front.
Okay. And what exactly do I have to say again?
Defendant, you know what? Go fill out the judgment form. I'll put it under paragraph 10. I got it. Okay.
I actually have it filled out, but this, it wasn't just for possession. This was.
There's a money portion of it too. It's, you wanted possession and you want a money judgment, or
So I can give you both of those.
you can give me the judgment form. The money judgment piece I've adjourned to March.
Okay, so then I don't fill out the money piece. All the rest is.
Do you have the,
I have a form. I didn't expect it.
okay, put the names on there. I'll fill the rest out.
Okay.
All right.
Thank you.
Thank you. Thank you, Ms. Gerler, and both of you have a very happy holiday.